You are mute. You are mute, Sonali.
Good morning to everyone. Respected Head of DHR, Professor Preeti Mishra ma'am, Professor Preeti Saxena ma'am, Dr. Rashida Athar ma'am, and Dr. Shashya Mishra sir. I'm privileged to be a part of this alumni lecture series, which we have started recently under the headship of Mishra ma'am. So I welcome you all to this fabulous platform. And now I would like to welcome and introduce our speaker for today. And she is our very own, very lovely Miss Shashya Mishra. She is right now assistant professor at Amity Law School, Amity University. She has graduated from DAV PG College, Lucknow, and she has done her post graduation, that is LLM, from our DHR department, Baba Saheb Bhimrao Ambedkar University, and she has also qualified NET, and right now she is pursuing her PhD. I would like to mention that her Viva has already been done, so in a coming days she is going to be a doctorate soon. She has her specialization in human rights, constitutional law, and she is serving in Amity Law School since 2014 August. She has been the member of core committee of National Seminar on the Rights of Child and Future of India, and she has been the co-convener also of an international seminar on law, justice, and governance issues and challenges. Her research interest lies in the field of human rights of vulnerable section, feminist jurisprudence, children education, environment, international armed conflict, cybercrime, and other contemporary issues, where which she always the torchbearer to keep us updated and through her webinars and all these things. Uh, she has written numerous articles over reputed journals, and she has been an outstanding author for a few chapters that I have gone through. Her research area basically touches upon the various facets of human rights, justice delivery mechanism, and she has completed her online course from Indian Law Institute Delhi on cyber laws. She is member of various international journals, and she was a special guest in e-seminar on menstrual debate in India. Still a long way to go, which was organized by Vidhi Seva Evam Samajik Utthan Samiti in collaboration with State Women Commission Uttarakhand. And recently, she has delivered virtual sessions on human rights, Article 21, and right to die. Impact on COVID-19 on environment sustainable development goals, human rights and perspective, and certification webinar on right to education with respect to COVID-19 pros and cons. She's a lifetime member of socioeconomic development studies. She's a editorial member of various advisory boards and international journals, Ad Valorem, and which is a journal of law. And she is a advisory member of Emerging Researcher and Lex Luxem. So this is what I have gone through about Shashya Mishra. She has been a very fabulous speaker as well. With her academic, this profile shows that she has been a very academic enriched person as well. So I welcome you, Shashya. Now the floor is open for the discussion and for your views.
Thank you so much, Sonali, for introducing me. And I must say this thing right now only, ki whatever kind of you can say fame or whatever kind of knowledge I have getting or whatever kind of recognition I am getting right now, this is all I can say because of the DHR family. I will not say it as an institute. I'll say this as a family. And today I'm again feeling like I'm coming back to my family. So firstly, I'm thankful to Professor Preeti Mishra ma'am, who is presently serving as the head and dean of legal studies. I'm thankful to Professor Preeti Saxena ma'am also. And along with that, I'm also very thankful to Rashida Athar ma'am and Shashi sir, as they were continuously guiding me in that 2 years journey of my LLM. And right now also, if I'm sitting in front of you people, I can say that this is something I'm achieving because of the knowledge which has been given by my faculties at that time. And then again, I am thankful to the Alumni Association also, which is working tremendously for the welfare of the alumni, and also for inviting me here today for presenting my thoughts regarding the rights of women at the time of COVID. So with this, I just want to ask once that whether I can continue.
Yes, yes, yeah, you can continue.
Okay, thank you so much. I think the PPTs are visible.
Yes, it is.
Okay. So once again, I just also want to welcome all the participants who are here, and I know most of them from this DHR department only. So I'm just grateful again to all of you. So again, starting with my topic, the topic is related to, you can say, the crime against women during COVID-19, a grave violation of human rights. Now, you all know that you all know this thing very clearly, that women come under the vulnerable group. And this is something which is very pertinent, and you all know this thing very clearly, right? Even a person who is not from the law background, or who is not from this domain of human rights, but then also this is something which all of us know this very clearly, that the human right prospect of the woman is something which is always, we can say this, that these rights are always been under the curtailed most of the time. Okay, so what happened presently also at the time of COVID-19, that when the females are living inside their houses, they are also facing certain kind of violence against them. So this entire lecture is divided, I can say it is divided into certain phases, where I'll start with the origin of the rights of women, or you can say jurisprudential aspect of human rights of women. With that, again, I'll come to the various international conventions and treaties, and how from the origin of this League of Nations and then the UN Charter, then how eventually, ultimately, you can say that presently, when whatever conventions or treaties have been signed. Later on, we'll see the reports, or we can see the stats which has been provided by the United Nations in context to crime against women. And then last, I'll come to the prospects, or I'll come to the scenario of India, that what is the situation prevailing in India at the time of COVID-19, and how the women are facing massive violence against them. So in that, I'll just show you the details, or show you the stats of National Commission of Women, that even at that time also, even at the time of pandemic, the crime against women is something which was continuing, and it didn't stop, and we can say that it is on spike. It has been immensely increasing at that time also. Okay, so starting with the introductory part, now this PPT basically shows this thing which I have already discussed, that the human rights of women are always being violated, they are always being infringed, and here at the time of pandemic, this trend of violating the rights of women has not stopped. So we can say that we are fighting this coronavirus outside our houses, and at the same time, women were fighting against this virus of violence inside their houses, inside the four walls of their house. So what happened, we all know that even that is a woman who is, or you can say as a housewife or a housemaker, or if she is doing certain jobs, all of them are being restricted inside the house. And what happened at the time of pandemic, we do know, we are restricted, movement was restricted. So ultimately, there are various causes due to which this crime against women or violence against women has been increased. Okay, now what happened most of the time, one of the thing that whenever going to the literature review or regarding this lecture, I found out that most of the crime or most of the violence which has been targeted against women at the time of pandemic, that is because of the financial constraints. And we all know that at the time of pandemic, most of the people have lose their jobs, or there was certain kind of salary deduction, or we can say that whatever salary they were getting, their demands were not being fulfilled. So one of the circumstances due to which the women were facing violence, and this is not something here we are in this lecture, I just want to make this thing very clear, that the study is not some, this violence criteria is not something it is limited to the developed or the developing nations, but the violence against women is something which is, we can say, it is present in all the countries, whether it is a developed nation or whether it is a developing nation. We used to say, and this is what we think also ideologically, that in the developed nations, in the Western countries, the women have more freedom, they are more outgoing, they can express their views. But what the UN data is basically reflected, that shows what? That like out of, we can say that according to the report of United Nations, they have quoted most of the time that out of the 3 women, 1 woman has been subjected to violence. And similar thing we are continuously viewing in our democratic setup also, where we have provided various kinds of rights to the women, but at the same time we have made legislations, we have made statutes, several laws, regulations, rules have been made for protecting the rights of women. But at this time of COVID or this time of pandemic, there was massive increase in the cases of domestic violence. So what is the role of human rights, and then how the human rights can protect the you can say rest of the rights of the women? Because most of the time, or you all know this fact, that we used to say that human rights are something which are indivisible, they are universal, they are available to all without any distinction. And textually also we have read this fact very clearly. Then what is the you can say what is the need for doing such kind of violence? So first thing which we must understand at this moment or this time of pandemic, at that time of pandemic, that is textual content, whatever is given in context to human right protection. UN has really trying hard to just restrict this kind of violence. And so, and then you will see further in my PPTs on this work that how in 2020, in 2021, time to time, WHO, UN has given their guidelines to restrict violence. And then ultimately how Indian judiciary has tried to protect the rights of women. This is something which is, I can say, you must know also. So this lecture will be more, it will be more informative in the nature, rather than you can connect it with the societal aspect, you can connect with the textual knowledge, and then I think you will get certain new kind of knowledge from this lecture. So moving ahead, now we all know that there are certain traditional crime against women, and this is something which we used to read time to time, that is sexual harassment, acid attack, rape, pornography, domestic violence, and cruelty. So these are the traditional crimes, where for which already there were treaties, for which if we talk about India, we have the laws also. But what happened at this time of pandemic, along with this traditional crime, certain new dimensions of crime has also been emerged. And what is this new dimensions of crime? Now we are living in the era of technology. So that crime is not just restricted to physical violence or certain kind of verbal aspect, but now with this technology also various kinds of crimes has been committed against women. And OECD, this is again an organization of UN, it has presented its report in the year 2021, where OECD has said this thing clearly, that now we are living in an era that we are more inclined towards technology. And this technology is again a means for creating violence against women. Okay. So what happened? What is happening at that time of COVID or pandemic when we all are restricted against women, especially, that firstly they were facing the traditional kind of crime against them. Along with that, they were facing the new nuances of crime, new dimensions of crime, especially the online crime. So here I'll just discuss majorly the two kinds of crime. One is in the scenario of domestic violence, another one in the phase of online crime, or you can say cyber crime or a virtual crime, whatever they are facing when they are sitting inside their houses. Okay. And the irony is that according to the reports, in India, if I talk about India especially, females do not have more access to mobiles. Okay. So even if they are not having more access to the mobiles, then also crime against them with the help of this new technology is not restricted. And this is what National Commission of Women has also quoted, that during this time of pandemic, cybercrime has increased along with the other kind of crimes against women. So now at this time, you can say that the crime against women is not something which is restricted to certain traditional kind of crimes, so which we usually read since childhood. But with the advent of technology, with the emergence of technology, now it is something more than that. So now coming to the next aspect, that we are discussing about the basic rights of the women or the human rights of the women. Then what is these human rights? Now, human rights is something which we used to say time to time, that these are the rights which are available to all. These are the rights which are made for the well-being for each and every person. These are the rights which are universal in nature. And then according to one of the article of the Harvard Law Journal, it has quoted this fact that the human rights scenario, or the meaning of human rights, we can find it out in three different ways. Firstly, in the ethical concerns. So this PPT is about the ethical concerns, where people use to recognize those rights which they think that it is correct. And this is again having a very ancient origin. Like if we think that something is right, then we used to accept it. And as it has been mentioned here, that the Nobel laureate Amal Sen also quoted this thing, that human rights are primarily ethical demands. Ethical, which are mainly based on the morals. And we all know that morals differ from one country to other country, one state to other state. So this theory, which is based on the ethical concerns, this is also talking about the concept of natural law. This is also talking about the justice, fairness, but it is more inclined towards the that what people want to accept. That is, they will feel that this is their human right, or this is something which is something that they need, or this is something which has to be protected. And as a jurisprudential aspect, we used to say that rights are something which are mainly the protected interest. So ethical jo concern hai, or you can say the ethical aspect, is something which is based more on that what people want to adopt as a part of their ethics, as a part of their morals. And then as the theory of Rousseau has been quoted here, which says that then again, if certain rights are being provided, then obviously these rights are being provided for the for a better personality, or for having a better lifestyle, or for having a proper status. So Rousseau said this thing, that these rights are the natural rights, and these rights are being provided since birth, or these rights are something which are provided to all, or you can say it has been provided since birth, since the time a person has been born. And then the state is under an authority to protect these rights. And this is the theory of natural law school. where whenever when you have the national law school, when there is a conflict between the church and between the king, ultimately the whole soul crux, or the whole soul, you can say in one line, if we want to say what is the natural law school, then basically it is talking about fairness, it is talking about transparency. And then when we were moving towards the modern aspects of natural law, their state has been given certain responsibility, which means the king has given certain responsibility, where the king has to protect the interest of the people, where the king has to protect the rights of the people. So ultimately, this ethical concept or the ethical concern in context to human right basically revolve about around the ideology of fairness, about the ideology of justice. But according to these scholars, people will accept those aspects, those rights as their human rights, or they'll say think that these rights will be protected, which they feel as ethical, which they feel as moral. Similarly, the next theory is related to that human rights as legal rights. And these legal rights, law means what? That there should be certain kind of text, there should be certain kind of code of conduct. So this theory, we can say, is something, again, we have to go back to the jurisprudence, and then again we have to see the analytical school up to certain extent, where there was a demand that the law should be codified. So when we used to say that these human rights are legal rights, it means basically that there should be certain kind of text, certain kind of codification of the human rights. And then who will make these rights? So who will codify these rights? State will codify these rights. So the authority is given to the state. Now, what we used to read, that under the analytical school, that law is the command of the sovereign. And what the analytical school demanded, basically, that whatever will be the situation, the law has to be codified. And it has to be codified by a sovereign. So here we can say that this aspect of human rights, or how you will define human rights, it is a result of certain kind of formal norm creating process, where we have read different treaties and conventions, and our entire human rights, you can say, is completely based on the treaties and conventions, where there were numerous treaties and conventions. There is an International Bill of Rights. So this is the theory actually which supports these treaties and conventions, which supports the ideology that the human rights are to be codified for maintaining the relation among the states. And this is for what the international law has been made. International law was made for what? That is to create good relations among the states. This is, again, if you have read the UN Charter, in that also, what is the principle or purpose of UN Charter? That is to maintain the good relation among the states. And for that, what is required? That there should be certain kind of codification. Most of the time, if we just compare this Western ideology and then we used to apply in India, we used to say that we also have human rights. This is something which we already used to know. Then why we are reading these rights or the Western aspects more? And then ultimately, what happens eventually, that finally that they are being codified. So once the things are being codified in the international scenario, or if it has been codified by the sovereign, it has to be implemented. As India is having a very ancient civilization. But what we used to say, even if we read any of the part of international law, we read the human rights, if we read the humanitarian law, we have written these things in our scriptures. But it is with the efforts of, we can say up to certain extent, the efforts of the Western countries that they have made the separate treaties and conventions. And then ultimately, we have also incorporated the principles of those treaties and convention in our constitution also. So obviously, whatever treaties or whatever we can say conventions which are being made by the sovereign, by the state, has to be implemented. So the first concept or the first concern is more tilted towards the ethics, towards the religion. So if I want to feel, if I have a reason to accept this as a right, then it's fine. But what the scholars said, that even if you are accepting it, that right must be just, fair, and reasonable. So we can say that the origin of the concept of human rights is majorly from the natural law philosophy, where the scholars like Hobbes, where the scholars like Rousseau, they have discussed the importance of basic rights. They have used the term basic freedoms. And they have said that the state cannot restrict certain rights or certain basic freedoms. And presently, we were reading these basic freedoms or basic rights as human rights. State is under, you can say, a duty to protect the rights. And from there only the concept of constitutionalism has been emerged by Hobbes. Obviously, state is like, it is something which means restricted governance, which means what? That even though the rights, state is sovereign, because we have read that the state is sovereign, state has to make certain formal norms. But even if the state is sovereign, state has to work under certain restrictions. And what are those restrictions? Again, the basic freedoms, again, the fundamental freedoms. And this is something which is human rights, a fundamental freedom, the basic freedoms. So these two concepts of theories of, we can say, that how human rights has been evolved, we can see in the natural law theory also of jurisprudence, and again up to certain extent only we can see it in the analytical law theory or the positive law school. Positive means what? That the law must be given by someone. Positive term, which has been derived from the term positus, means given by someone. So these two theories is something, again, the origin from analytical school as well as from the natural law school. And the effect of these theory is that the ethical concern is based on the concept of reasonability, just environment, and the human rights as legal rights theory, or this analytical theory, is based on that even if we are talking about the basic freedoms, even if we are talking about the fundamental freedoms, it has to be codified. It has to be written somewhere. And therefore, the Magna Carta came in the year 1215. Because certain freedoms were being written somewhere. So, what we can say right now, or what is the importance of, or how it has been originated, human rights have been originated. So again, firstly, we have to see the jurisprudential aspects. Then moving ahead, the third concern, or how the third field from where the human rights has been evolved, that is from the social claims. That is when there is certain kind of suffering, when the demands of the people are not being fulfilled. So here comes the role of the NGOs. Here comes the role of the activists. Here comes the role of the people who are working at the grassroots level, who can visit such places, who can go to such places where the rights of the people are being violated. And if you read any of the treaty or any of the convention that is related to human rights, when we talk about Beijing, if we talk about Vienna, we talk about other treaties, NGOs' participation was something which was persistent. And they are especially been invited to the conferences to discuss the grievances, or what can the community or what can the committee can do for protecting the rights of vulnerable section. And in that, women also been a part of that vulnerable section. So Vienna conference, we used to say, is at a world conference on the human rights, in which people from NGOs were present. Beijing conference, similarly, which was the impact of globalization. And in the Beijing conference, the treaty if you read the treaty, you will find out that it is generally discussing the 12 concern areas. And that is something related to the aspect of globalization. That although we are living in the globalized era, but then the rights of women, something which are again not being protected. And in that Beijing conference, the violence against women has also been discussed. So society, or we talk about social claims, what society demands. What is the need of the society presently? Now, law is something which keeps on changing with time and pace. Maybe the things which were not important before pandemic, they were more important after pandemic or at the time of pandemic. This is just merely an example. So what is mentioned in this theory particularly, that the rights emerge from the need of the society, the claims of the people. So in the ethical concern, rights has been emerged from the religion, from the ethics, from the morals. Second come the positive law phase, where the demand for codification of rights has been asked, or the rights had to be codified. This was the demand. And third comes the human rights as social claims, where when society needs certain kind of protection or certain kind of rights, who were suffering from injustice, who are facing injustice, then those rights are to be protected. And here we can say the role of NGOs. Here we can say the role of special rapporteurs that have been appointed by the United Nations time to time to see the violence, to see the issues of discrimination, to see the issues of children or women, those who are facing atrocities. That can also be included in the present scenario. So now we come to the jurisprudential aspect of women rights, or you can say how the women rights has been evolved from the time of 1945 onwards. Prior to United Nations, or prior to the UN Charter especially, you can say, there was League of Nations. And after the League of Nations, there was a war. And we all know that what is the impact of any sort of war. It ultimately violates the rights of the people. It ultimately create a situation where the people are not free. They were not live with proper dignity. They were not having proper assets to survive. So what happened after the failure of League of Nations? This UN Charter or United Nations, again this created a UN Charter, and from the UN Charter actually the entire journey of evolution of human rights has been started. Where you can see here completely that after 1945 onwards, actually the United Nations with the help of General Assembly started working on certain documentation in context to women rights. And as you can see here that at that time, Eleanor Roosevelt, they sent one open letter to the women's world, and there what she described that women have their voices in the United Nations. And it is, you can say, because of her efforts, ultimately in 1948 we have this Universal Declaration of Human Rights. And after that, there were plethora of conventions and treaties where it has been said time to time that the women right is also a human right. Now there is a need to protect the rights of women, human rights for all. Time to time we used to read all these things. So from 1945 towards the era of 1975, you can say several treaties were being signed, and those treaties will just go through the gist of those treaties further. And when we were in this phase of development of these rights, or we can say from 1945 to 75, international community somehow has understood this fact very clearly that when we were talking about equality, it is not only restricted to certain facets of life. It is not just restricted to food, shelter, but now there is a need to have certain specific treaties or international documents for protecting the rights of women. So in this phase from 1945 to 75, some declarations came for reducing violence against women. But as we know that those were merely the declaration, and declaration do not have much binding effect, impact. So although they were declaration, they have been signed by the nations or they've been ratified by the nation, ultimately because of their not proper implementation and they're not being properly utilized, or the states are not properly willing to use those declaration in their domestic laws, that treaties or those declarations do not affected or do not protected the rights of women. And the irony is that still they were merely more declarations which were directly targeting about this aspect of violence against women. And if there is certain convention or there is certain concrete treaty, so that is again more regional in nature. So from this era of 1945 to 1975, in between that there was a situation of Cold War also. After that, what happened that several treaties were being signed, like the so from here onwards, that is from 1976 to 85. Now this is an era where several treaties were being signed, like we can take the example of Mexico City, that was in the year 1975. Then we have the Copenhagen, then we have the Nairobi Conference of 1980. And this was the time which was being declared as the International Women's Year, that is the phase of 1975. And then further it was being declared as a decade for women. And this part which reflects that women's issues were not limited to gender equality. It is something more than that. because when when we were in the treaties were in the phase of, or we can say when the human rights were in the phase of development in context to women, most of the time we used to say that we are talking about gender equality, gender equality. No, it is not something which is just restricted to gender equality. Here we are not only talking about that we are just providing equal rights, but the emphasis will be rather more on that how you are going to protect those rights. Like if you are providing, just as an example, that if you are saying that men and women both can work, fine, both can work. But when that same woman is being beaten by her near and dear ones, or certain kind of violence takes place against her, then where is gender equality? So gender equality is not merely just limited to providing equal opportunities. It also includes the aspect of dignity. It also includes the aspect of equal treatment with proper respect. This is what happened, because earlier, whatever treaties you might have read or people will read, they were related to providing equal status to women. Yes, we are providing right to vote to women also, along with the men. Yes, you are providing equal status. You are providing certain avenues for the women. But what is the need right now? That along with the equal opportunity, whether that female is safe enough to do her job or to do her work. So from this era of 1976 to 1985, it has been said by the international community that the rights of the women is something more than the gender equality. And in the Nairobi conference, that took place in 1980, there for the first time certain consciousness has been developed regarding this particularly this issue, that women issues are not limited to gender equality. So again, I just want to connect again with the natural law philosophy, where the scholars of natural law philosophy or natural law school basically says equal opportunities must be created, equality must be prevailed. But what about equal treatment? What about equal amount of dignity? So this phase is equally important in the evolution of human rights of women, or jurisprudential aspect of human rights of women. Moving ahead, then comes the next phase, that is from 1985 onwards. So as we have discussed earlier also, now the women rights are more than gender equality. So here again, the issue of violence has been emerged in a more declarative manner, where it has been said by the international community, or where it has been said by the, you can say, the states especially, that violence is something which is again violating the rights of the woman. And even if we are providing equality, even if we are talking about the aspect of gender equality, then this feature of violence, or this kind of another aspect of violence, is again restricting their rights. So the women rights is something which is obviously and continuously, it is in a phase of development. because in 2021 also the UN has given certain themes so that the violence against women can be restricted. And that was a time of 1985, where we can understand this thing clearly, that even if we talk about the developing nations or the developed nations, violence was something which was persistent in both kind of countries. And even at the time, if we particularly talk about India, when judiciary has to give certain decision in context to issues related to violence, we do not have any specific law. We have only IPC, we have other procedural laws, but we do not have any specific law. We do not have the Domestic Violence Act. Came very late 2005. So what happened at that time, that judiciary also tried to quote the or try to include the articles or phases that are being mentioned under the international treaties and conventions. We can take the example of Vishaka, where the court took the help from the Vienna Conference. And after the instance of Nirbhaya, we have the law related to protection of women at workplaces. That is in the year 2013. And the judgment given in the Vishaka case was of the year 1997. So we can see this thing clearly, that even though the rights have been violated, even though there was the grievances or there was the issues of violence against women, the laws are being made lately, or even the judiciary has to incline towards the international treaties, the codified laws, the codified treaties related to human rights. So this phase of women rights, that is from 1985 onwards, it is again one of the most important phase, because after that we have the Vienna Conference, after that we have the Beijing Conference in the year 1995, and then it has been said by the United Nations and the member states of various treaties that now it is a high time and we should restrict any sort of violence against women. And even after the 20 years of Vienna Conference, what is the tagline of that Vienna Conference plus 20? Zero tolerance towards any sort of harassment, any sort of violence. So the phase after 1985 is again, we can say, an important phase where the rights, or where the women rights are again a center of attention, and several treaties were being signed after this phase. So now we come to that International Bill of Rights, which has been emerged after the this UN Charter, which we have earlier discussed also, that after the making of this UN Charter, ultimately what happened, that in 1948 we have the Universal Declaration of Human Rights, then we have the International Covenant on Economic, Social and Cultural Rights, and then we have the International Covenant on Civil and Political Rights. And these three documents completely, entirely in one pack, we can say that it is a International Bill of Rights. So when at the time of the making of this International Bill of Rights, what the committee members have decided, that they want to have three documents. One, which they make as a declaration, where basic, we can say basic aspirations have been mentioned. And the rest two documents will be in the form of the covenant, which means that these covenants will be more binding in nature. And according to their plan, they have also made the documents. One is in the form of declaration, other two in the form of covenant. With that, they have provided the optional protocols also, where the mechanism of complaint mechanism has been mentioned. That is in the optional protocol 1. Because the declaration is not effective in implementation, cannot be implemented that much properly. It do not have any kind of binding force. And in these covenants, along with these two covenants, or you can say this covenant on civil and political rights, the right to live with dignity, right to life, these rights have been included, which are of paramount importance, because when we are talking about the violence scenario, which is completely connected to the life of an individual, then the treaties, these covenant equally mentions this aspect, that life is something which cannot be curtailed. Right to life is something which is of great importance. And the initial phases or the initial articles of these documents, these three documents, I'll say, basically tried to create an environment where the dignity of the individual can be maintained. So when we say that the dignity of the individual must be maintained, it includes the women also. And therefore, the first article of UDHR is of immense importance, which says that all are born free and equal. And everyone is having an inherent dignity. And dignity, we can say that it is something which is more important. Right now, also in 2021, we can see here in case of India, where the allegations were being made in the cases of Me Too cases. And the court said what? That dignity of the individual is rather more important. Dignity of a female is more important than the reputation of the man. So, like, the case was related to defamation, because if you're writing something on social media, like in that scenario of Me Too, was completely it was said that it is an instance of defamation against me. The court said that no, the dignity of the female is more important in comparison to your reputation. And this was something which was clearly inbuilt in these treaties or the International Bill of Rights, which completely deals with the aspect of, or you can say, the concept of dignity of the woman, which is of immense importance. Now, coming to the UDHR, which came in the year 1948, it is Article 1 clearly reflects the philosophy of the declaration. And as I am telling you already, that it, in one line, it just says that all human beings are born free and equal in dignity and in rights. So, in its very first article, the document itself reflects that what it wants to say, or what it wants from the member states. Further, in rest of the articles, again, I can see that simply Article 2 talks about the principle of non-discrimination, 3 talks about liberty and security, life. The responsibility is again on the state. Principle of non-discrimination has to be adopted. And in the last articles of this document, you can see clearly that state is under an obligation to protect the rights of the citizens. And it has been recognized completely that right to live with dignity is one of the human right. And in the domestic framework also, state should try to incorporate them. And then again, if I connect, and again, if we see this, I connect this UDHR to the Constitution of India. To talk about equality, it is mentioned under the UDHR. Under Article 7, it is mentioned under the Constitution of India under Article 14. Similarly, right to live with dignity, it is inherent in the language of UDHR, and it is available under the Constitution of India under Article 21. So, UDHR was something we can say that most of the articles we have taken help from the UDHR also, because at the time of the making of the constitution, the UDHR was already being made. So the Constituent Assembly members, they basically try to incorporate those provisions which have been recognized as the human rights there in the constitution also, and then they have their own debates. Some of the provisions we have incorporated from the Constitution of USA, similarly from rest of the countries also some of the provisions. So what is something which is important right now here, that even the law of the land in our country, it has been somewhere incorporated the principles of UDHR, and the judiciary, which is which works for interpreting those provisions, they were trying to implement the norms or implement the wordings of the constitution while giving their judgments. And there were plethora of cases where the court again and again said, like one of which I have already told you, the case of Me Too allegations. And then again, several cases, the Vishakha case, several cases are there where the dignity of the woman has been given immense importance, and any kind of violence against women was something which was against their right to live with dignity, right to life and right to liberty. So in the UDHR also same principles have been incorporated. Next we come to the International Covenant on Human Rights, where we can say that two documents were there. One is ICCPR and the next one is International Covenant on Economic, Social and Cultural Rights. And in both the documents somewhere, some of the important articles I have only quoted here, like Article 3, 6 and 7, which deals with the specific rights of the citizen. And Article 3, as you can say, that talks about the principle of non-discrimination, again along with right to life, and any kind of torture and inhuman treatment is something which is completely prohibited. So the International Bill of Rights, we can say, has opened an avenue for the rest of the treaties also for protecting the rights of female. So moving ahead, after 1966, the two covenants were being made in the year 1966. Later on, we can see here that is the Convention on the Elimination of All Form of Discrimination Against Women, that came in the year 1979. And here we read the preamble of the document. It has been mentioned there clearly that we are making this document again to reaffirm the goals that were mentioned under the UN Charter. We are making the document again reaffirming the goals that are being mentioned under the UDHR. And the states has to make policies. State has to make certain laws for combating violence, or you can say any sort of discrimination against women especially. Because we have already seen in the previous documents or in the International Bill of Rights, it is given there that discrimination is prohibited, inhuman treatment is prohibited. So here, under the Convention on the Elimination of All Form of Discrimination Against Women, the aspect of discrimination was something which was discussed in detail. And after, in Article 1 is again as of immense importance, where the term discrimination against women has been defined. And while defining this term discrimination against women, it means that whenever there is any kind of biasness, whenever there is any kind of restriction in context to rights of the people, in context to rights of men and women, then it will be considered as the discrimination against women, when there is a discrimination between men and women. Now, in 1979 also, when we were again, we come to the same aspect again, which we have discussed also again, that gender equality is this human rights of the woman is something more than gender equality. And therefore, the international community has decided to come up with a separate document for eliminating any sort of discrimination against women. And in its article 1, it basically defines the term discrimination against women. What does it mean? That is any kind of exclusion or restriction on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, exclusion, restriction, distinction, or specifically if we talk about exclusion or restriction, COVID has reflected both the aspects. Why? Firstly, the movement wasn't restricted. It is on the because of the pandemic. But inside the house also, the females have been restricted. That whether you have to do this work or not to do this work. You have to listen whatever your husband says or whatever your family members says. And this is something which is, we can say that it is something which is prevailing right now also. This is the Treaty of 1979. So United Nations has very clearly mentioned these technology when you are distincting, when you are excluding, when you are restricting a female from a male or a female, then it will be considered as a kind of discrimination. Later on, we have the other document. Now, this is a World Conference on Human Rights. That is again one of the most important treaty, that is a Vienna Declaration. And in this Vienna Declaration, the states have completely recognized this aspect that any sort of harassment, whether in the public or in the private life, is something which is prohibited. And the state has a responsibility again to make laws for protecting the dignity of the woman. And therefore, again, I will come to the same case law. That is when we are talking about the case of Vishakha. What happened? The court has taken help from these treaties only, because we do not have any codified law at that time, and the court then gave certain guidelines. So in the year 1993, which is this part of Vienna Conference, where the initial passages of Vienna Conference talks about the UDHR, the UN Charter, the International Bill of Rights, and then ultimately in its different passages, they have mentioned about that any sort of violence against women, whether it is in their public life or it is in their private life, is a kind of violation of their basic human rights. Then next comes a declaration. Now, this is again a declaration on the elimination of violence against women in the year 1993. So this is one of the document which we can say that is directly dealing with this aspect of crime or violence against women, and its article 1 defines the term that what will be considered as the violence against women, where it has mentioned the kind of a gender-based violence, which is not only physical, but it also includes the psychological harm or suffering to the woman, and it is something which deprives the woman from her liberty. And then again, what is important to see here, that such kind of violence is whether it is occurring in her personal life or it is happening in its public life, this is coming under the purview of the term violence. Then further, we have the 4th World Conference on Women, or we can say the Beijing Conference in the year 1995. And in this 4th conference, or in this Beijing Conference of 1995, 12 areas of concern were being discussed. And in these 12 areas of concern, this part of violence has also been included. And it has been said that now this was a treaty which has also discussed the issues of globalization. that what is globalization and how it is affecting the rights of the woman. And in those 12 concern areas, they have discussed every aspect, that what related to employment of the women, related to uh, violence whatever they are facing in their day-to-day life, related to discrimination whatever they are facing, and in those 12 areas. So here, this is again one of the most important treaty where it has been mentioned that violence is something which again restrict the women's right to enjoy their human rights in as fully or completely. So further, this fourth world conference is again of immense importance, reason being, and if we used to see this, apply this, or we used to incorporate the provisions, or we see the situation in India at that time, because in 1991 we have also adopted the philosophy of globalization. We have also made our markets open for all. So even at that time, when the females were working, they were started working because there were more of industrialization, more of work, then also they were facing violence. Then also they were not treated with complete dignity. So the term violence, as it has been discussed in the previous documents already, that it is something more, not restricted only to physical violence, it is more of the psychological violence also. It is something which is related to cruelty. So the fourth world conference, or the Beijing conference, which came after this, you can say the globalization, or it has discussed the issues at the time of globalization, is also discussing about the violence scenario in context to women. And then again, as I've already telling you, that this here again the term violence against women has been defined similarly as it was defined in the Declaration of 1993, where it has been said that the violence is something which is dealing with the physical, sexual, or psychological harm, and it is something which is again restricting the liberty of the female. And then the most important aspect of this document is that violence is not only restricted to, or the crime against women, you can say, it's not only restricted to dowry related crime or marital rape or any kind of female genital mutilation. Certain other kind of crimes are also being included, like the violence related to exploitation, or the crime related to exploitation. How we can say this, that right now also, during the time of pandemic, what happened, that we all just shifted to the online world, and the issues of morphing was something which was increased, where the images of the females are being morphed and then they are being sent for financial gains. And in that, what happened basically, the dignity, again the dignity of the woman has been violated. And the irony is that even facing such kind of crime against them, we're not reporting the cases. So in this Beijing conference also, they have discussed the different dimensions of crime against women, or different dimensions of violence against women, which we can see right now also, because in 2021 again a conference took place where the United Nations have reviewed this Beijing conference only in one-day session. They have reviewed this Beijing conference only, and they have again discussed this aspect, that now the crime against women is not only restricted to domestic violence, not only restricted to harassment, it's not only restricted to cruelty, it is something more than that. With the technology, now the dimensions of crime against women has also been changed. Then now this is again one of the important document, which is the Istanbul Convention. And this was a convention which was made by the European Council, and This is the first binding treaty in context to violence against women, or you can say especially the domestic violence against women, where under Article 1, which discusses the purposes of the convention, it has been mentioned that it is again the responsibility of the state to protect the women against any kind of violence, any kind of crime, any kind of you can say offenses against them if they are being committed. Then yes, so after that, the Istanbul Convention has recognized that what has to be done in order to restrict the crime or restrict the violence against the woman. So what this convention basically discussed, or what this convention basically said, that firstly, it is the responsibility of the state to prevent all forms of violence against women, then promote equality between men and women. Now this is again general, and then to investigate the instances of crime or violence or offense against women, and then proper punishment has to be given. Most of the time we used to say that international law is a weak law. This is what we have read since the starting. We used to read the theories of Austin, what he said, that it is merely a positive morality. And here in this treaty, it has been said that investigation along with the punishment is something which is important. So Istanbul Convention, again in the year 2021, Turkey withdrew from this convention. Many of the developed countries, many of the, like we can say, such countries or leaders, they are holding the place of leader. They have also not been the part of this treaty. Like we can take the example of Russia. So this Istanbul Convention is, you can say, trying something which is making a more concrete norms in context to eliminate the crime or the violence against women. And with that, it has discussed that not only to ensure gender equality, but also to investigate and punish if the instances of crime being reported. Then comes the next, that is the MDGs, which came in the year 2000, and this Millennium Development Goals also deals with the aspect of gender equality and how to empower women. And then again, a state is under a duty to protect the rights of women. And similarly, in later on, we have the SDGs, or the Sustainable Development Goals, which were also dealing with the aspect of violence against the women and girls. And it has been said that again, it is the responsibility of the state to eradicate any sort of violence against women and girls, whether it has been in their public life or it has been there in their private life. So the 17 sustainable goal, in that certain goals have been just like revolving around the gender equality. They were revolving around the justice also. Last few SDGs deal with the access to justice also. And then we have the SDGs like 2030 also. And so what is happening presently, we can say that already we have these documents, or several documents, several goals are being made. Like in 2000, we have MDGs, which are to be achieved till 2015. And after that, we have SDGs from 2015 onwards. And what is happening, like till 2021, at this phase of COVID, from 2020 to 2021, discrimination, violence, crime against women is something which is on peak. Then next comes the efforts of the UN. Now this is something which we can say that what UN is doing time to time. So UN is again making certain, they are adopting certain resolutions. So as you can see here, in 2012, again, after this Istanbul Convention, they have made a resolution like if there is instances of, if there is an issue of violence, then the culprits or the people who have been involved in that, they are to be punished. And then the state has a responsibility to enforce the norms related to protection of women. and safe environment has to be provided. Similarly, there is another resolution that is related to elimination of violence against women and what kind of remedies are being has to be provided. Now this resolution is again been something which has been like originated from the uh, Convention on the Elimination of All Form of Discrimination, that is CEDAW. It has been evolved, and here again it has been said by the United Nations, like what has to be done right now. Already we have made several treaties, already we have made certain documents, but still the situation is same. So in 2011, 2012, 2013, time to time, United Nations has came with the different resolutions. Now we come to that how the pandemic basically violated the rights of the female, or what kind of violence or crime they have basically noticed. So as it has been already been discussed that there were increased cases of domestic violence, and here it has been also been mentioned that what were the causes. So this is something which already been, I have said that economic stress is one of the most common cause of the violence against women at the time, or the crime against women at the time of COVID, along with the other measures. But what is more important, that is the higher levels of social and economic stresses. Then we can see here like role of United Nations. And as it has been said by me time and time again, that crime or violence against women is not only something which is prevailing or which was prevailing at the time of COVID in developing nations, but was in the developed nation. And therefore, United Nations came up with one tagline which is known as shadow pandemic. And here, United Nations, like as it is mentioned here, that United Nations had recognizes home violence in opposition to ladies as a shadow pandemic. So United Nations, which has been created for protecting the rights of the individual, where it has mentioned the term dignity again and again in several of its articles, fundamental freedoms, fundamental rights, these terms they have used in their several articles. After that, we have the Bill of Rights, and then right now we have discussed several treaties also. What is what was present in all these treaties is dignity is of paramount importance. Dignity has to be protected. But even at the time of pandemic, when the people are being restricted inside their houses, they have to stay in their houses only, then also the crime, or you can say the violence against women, has not been restricted. And then the United Nations has launched a campaign which is known as shadow pandemic. That has been something started after the lockdowns. So the scenario of gender-based violence in all the countries, you can say more or less is same. And one of the most important cause of such kind of violence, as it has already been discussed earlier also, that is the financial constraints. And this is what has been said by the National Commission on Women also, that there is a enough hike in the cases of violence against women. And now whatever complaints we are getting, it was not only restricted to traditional kind of crime, but in this era of technology, several cases of cybercrime has also been reported against the female. Later on, as I have discussed this thing, that now at the time of COVID, the dimensions of crime against women has completely changed. Earlier, I think in my second slide, I have shown you the traditional kind of crimes that are being done against the woman. But at this time of pandemic, what happened, and traditional kind of crime, we can say, because now the people are being more inclined towards the technology. So even though the person is living inside their house, even though there is no instance of domestic violence, they were facing a certain kind of crime by the people, or by the fake profiles, by the accepting certain kind of fake friend request, and then how their entire profile has been changed, or how their pictures are being circulated without their information. And again, if I talk about cybercrime specifically, what the studies show completely, that the females were not much aware about these kinds of crime, because they were using the technology, but they do not know that how to use the these technology properly. And the result of this, what happened, that they have to face certain kind of crime. So digital crime or digital violence, we can say, is something which is very evident at the time of COVID-19, along with the instances of domestic violence. So what like online or digital violence, cyberbullying, non-consensual sexting, doxing. Doxing basically means what? That this identity of victim, or the information about the victim, has been disclosed. So doxing is something which is again a new terminology, we can say, up to a certain extent, when we talk about the crime against women. Let's suppose if a female is a victim of certain crime, then her identity, her information was made public on the online platforms. And therefore, now this is something which can again we can connect with right to privacy. And we have the case of, like in Indian scenario, we have the case of K.S. Puttaswamy, where it has been said like that what privacy is a fundamental right. And if we talk about the cyber law, or if we talk about the Information and Technology Act 2000, cyberbullying, trolling, doxing, sexting, online grooming, the laws against such kind of crimes are very weak. Spamming is again one of the part or aspect of cybercrime. We do not have a specific legislation regarding spamming. And what happened, that because of the lack of awareness, women used to accept the offers whatever they are getting. Phishing again, even though at the time of COVID, we were working from our homes, we were receiving bulk messages. And where again and again it has been said that if you click on this link, you will get certain money, you will click on this link, you will get certain benefits. So what happened actually, or what happened at that time of pandemic, even though we are sitting at our home, we were using the technology, but with this technology also several crimes has been committed against women. And this is what National Commission for Women has said also very clearly, that like already I have told you, that now there is an increase in non-traditional kind of crimes. We are moving ahead of cruelty, dowry debt, marital rape. We were now in the phase where technology is hampering the or violating the basic right of the woman to live with dignity. So these terminologies, like several crimes have been included. Few of them I have mentioned here, like morphing is again one of the such crime where it has been said, or where what kind of crime is morphing, where the images of the person has been morphed for getting certain benefits, and the female is not knowing this fact that already her pictures are being morphing has been done. So what happened, that is Organization for Economic Cooperation and Development, which includes 36 nations. They have also presented their report at the time of pandemic, and what they have said, that confinement measures, because of confinement measures, crime against women has been increasing, violence against women has been increasing, and similarly, because of the rapid inclination towards the technology, crime against females is on the peak. And here in their report only, they have discussed the issues of cyberbullying, they have discussed the issues of morphing, they have discussed the issues of this pornography also, where it has been mentioned trafficking also, online trafficking also, where the girls and the women are being targeted especially by the predators for committing crime against the females. So the crime against women, or the cyber crime against women, is global at the time of pandemic. And the Organization for Economic Cooperation and Development, that is OECD, it has also mentioned this in its report, and they have said that already this United Nations, or there were separate programs have been launched by United Nations time to time at the time of pandemic, and this UNDP, that is the United Nations Development Program, it has also approaching the governments, or it has also been in contact with the governments of the states, that what they were doing for curbing the crime or for curbing the violence against females or against the women. But then also right now what is happening, that is new kinds of crimes are being emerging, and in that scenario online crime or cyber crime is something which is on peak, which is on increase. Now in the report of OECD, it has been said again that how the women are being targeted inside the house. So OECD report basically said that the intimate partners, they were actually violating the rights of the female by harming them psychologically, physically. And after that, in its report, OECD said that this is the one aspect of the crime or violence against women. And on the other dimension, the other facet of the crime against women, that now the females are more inclined towards the technology. So this technology, which is again, we used to say science is a boon or a curse. So this technology aspect is again something which is nullifying, or it is something which is infringing their dignity, or violating their dignity or the right to life with proper dignity, or whatever reputation they have. OECD report is equally important because again and again they have mentioned that like if they have mentioned this thing very clearly, like in case of violence against women, what they have mentioned, that women have been restricted inside their houses because of the lockdowns. because of their families, or they're living there, their children were living there, and then also they were facing violence. Most of the time, maybe it may not be physical, but it will be uh, psychological in nature. So what the report basically tries to summarize, that what we have read so far also, like in different treaties, they have mentioned the term violence means certain kind of physical, sexual, or psychological harm. At this time of COVID-19, it is more about the psychological harm which the females have noticed because of their intimate partners or because of their family members. And if they are not facing this kind of crime or this kind of violence against them, digital crime is something which they were facing. So OECD report very clearly categorizes the crime against women, that what kind of crime basically women are facing at the time of pandemic. Moving ahead, talking about the efforts of United Nations. So they have conducted a survey, that is the gender assessment survey, in 13 countries. Now these countries, or names of the countries are being mentioned here. And in these countries, they basically try to find it out that what are the causes of crime against women. And with that, what United Nations has done, or what they have discussed with the state, that they should provide certain kind of helpline numbers to the females who were facing certain kind of violence or crimes against them. So as it is mentioned here that in Bolivia or in Colombia, women can report violence in the pharmacies by using certain code words or by using certain expressions. Similarly, it is mentioned here that in Costa Rica, patrolling was something which has to be strengthened at the time of violence. And in Barbados, United Nations has suggested, or the state itself has taken certain efforts for establishing virtual courts, especially against the crime or violence offenses against the female. So this is something. This was something which is very clear from these PPTs, that this slide especially, that in the Western countries also, there were instances of crime against women at the time of pandemic. Similarly, what happened that in 2020, there was a political declaration which was adopted by the states on the 25th anniversary of Beijing Conference. And what they have discussed there, they have said that now there is a need to implement, firstly, to revamp the efforts in context to implementation of Beijing Declaration, and special emphasis has been given to the violence against women, or any sort of crime if it has been committed against the female, then in such situation, woman has a right to get justice. So it has been said by the member states especially that even though they were the signatory or they were the part of the treaty, what is important right now, that is they have to provide a safe platform to the females, as well as the justice delivery mechanism has to be made more quick. And therefore, like in the previous slide has been mentioned, that in Barbados they were coming with the virtual courts. So this conference or this political declaration was adopted at that time of COVID only in March. And in this declaration, one-day session was conducted where they were basically trying to again implement the Beijing Declaration and platform for action. Then next, what has been done by the United Nations. So as it has been mentioned clearly here, that they have recognized International Day for Elimination of Violence Against Women 2021 in the year 2021. And in that, they have given some specific theme also, that is Orange the World, End Violence Against Women Now. Now, what is the importance of this theme only, that is orange, the word end violence against women now? United Nations basically said that orange, they have just connected this color with sun, and sun, we all know that is a symbol of brightness. And they said that we are giving this theme especially, why? Because here we hope that the females must have a brighter future like a sun. So till 2021, we can see the efforts of United Nations. They have conducted conferences regarding the Beijing Program of Action. They have given, they have recognized this era of 2021, where they have given specific theme against the violence against women. And this shows that how the international community is concerned about the violence or the crime against women. And as the data also reflects it, that according to United Nations, 137 women are killed by a member of their family every day. So you can see the data very clearly that traditional crime, non-traditional crime, any sort of crime is something which is prevailing against the women, in spite of having several treaties and conferences, resolutions. And again, it is in 2021, at the time of pandemic, it is again on the peak. Now, talking about India. So in India, the situation is more or less almost similar, because UN is also making it efforts at international level, and here in India, along with pandemic, the cases of domestic violence has been rising, but has been increased. And what has been said by the National Commission for Women time to time, that although there were instances of domestic violence, but most cases were not reported properly. And then also there is a, it has been mentioned that 27% hike in the cases of domestic violence. And similar goes with the cyber crime also. So in India also, at the time of pandemic, the crime against women is something which has not been restricted. And then the National Commission on Women has categorized the crime against women in 4 zones. That is right to live with dignity, protection from domestic violence, harassment, demand for dowry or dowry deaths. Where they have said, National Commission of Women has said that right to live with dignity is again under a threat, because it is connected to rest of the crimes against women. So they have provided their data, where they have said that how the cases against women has been on peak at the time of COVID. Like as it has been mentioned here, the number of complaints of domestic violence received by NCW rose sharply from 2,960 to 5,297 in 2020. And this is the figure when even some of the cases were not being reported. So from 2,000 to 5,000, you can say the number of cases are being increased. Similarly, rest of the data, if we talk about rest of the crimes against women, then it is mentioned, or it is clearly, we can see that from 19,730 crimes which were reported in the year 2019, they were being increased in the year 2020 to 23,000. So what we have understand from these data, or what I have understand from these data, that even if we are living inside our houses, even if we have to see only, or we have to manage the work, everything is going from home, or we have to work from home, but the crime against women is something which has not been restricted. And even in the treaties also, if we talk about the Istanbul Convention also, it has been mentioned, or even in the report which has been submitted by OECD also, it has been said that any sort of crime is something which is violative of the human rights, whether it is stalking, whether it is killing of someone, whether it is if you are harming someone physically or psychologically, it is a kind of crime. And for such kind of crime, there should not be any kind of justification, but there should be punishment for this. So Istanbul Convention, you can say, it has defined every kind of crime, like stalking, like psychological harm, like physical harm. And then it has mentioned that state is under a responsibility to make laws for protecting the women. And in the same treaty, it has been mentioned that for committing a crime, there should not be any kind of justification. Therefore, when we were discussing the Istanbul Convention, three things were being mentioned, like especially the preventing the crime, then the gender equality, then to punish the person, investigate the issue, and then to punish the person. So even having such certain kind of rigid treaties which were not dealing any kind of justification in the aspect of crime against women, then also when we talk about the crimes, especially against the female, whether it is a developed nation, whether it is a Western country, whether it is a country like India, crime is something which is not being restricted. And we have laws also now. Like we have the Domestic Violence Act also, we have the Dowry Prohibition Act also, we have the IT Act also, if we talk about particularly cybercrime. Then we have our own penal codes where the crime has been defined and the punishment has been mentioned. But the crime against women is something which has not been decreased, and it has been increased at the time of COVID. So moving ahead, now we come to the data provided by National Commission for Women regarding the cybercrime. So cybercrime is a field in context to female. We can say that it is an emerging field, we can say, up to a certain extent, and therefore the number of cases in comparison to dowry debt or in comparison to domestic violence will be less. But at the time of pandemic, there was a rapid growth in that number also. Like the cases, like in the previous year, like if the cases of cybercrime were around 100 or 200, they were eventually rise to 700. And the cyber experts or certain organizations or NGOs, those who are working in this field, were providing protection to the female in case of cybercrime. They've said that most of the time female do not want to report such cases, because again it is related to her reputation and dignity. So, and the next thing, that they were not aware also that where they have to approach. Like in traditional kind of crime, we all know that when anyone knows that we have to go to the police station, then we have to write the FIR, then we have to move ahead. But in case of this cyber crime, what the female basically faced, that they were not aware about the procedure, that where they have to go, where they have to approach. So the cyber, and then our cyber experts also said this fact, that the cyber laws that were prevailing in our country, they were not adequate enough, or they're not sufficient enough to protect the dignity of the female. Now, the reason for the same, which I think that when the law was being made, it was being made for the e-commerce. And now what we have noticed, or what we can see right now, that there were other kind of crimes also. for which the law is not providing any specific definition, any particular meaning, and for any particular punishment also. We were mainly dealing with a few of these sections like section 43A, which were dealing with the compensation in case hacking has been done. Similarly, we were dealing with like 66A has already been held unconstitutional. And then we come to the identity theft. But whatever punishment has been prescribed in these provisions, they were not sufficient enough. So even if we are having the legislation, it is not effective enough to curb the crime against women. Now, these were the examples of cybercrime which have been on peak at the time of COVID against women, like the indecent exposure, like the unsolicited obscene pictures, threats, blackmailing, ransom demand, and morphing. And again, it has been said that these kinds of crimes, like if you talk about morphing especially, or blackmailing or threats again, now sometime in the women who are educated also, they also fall in the trap of such crimes without knowing the fact that who is sitting on the other side. So the cybercrime is like the rest of the crimes, like the domestic violence, like the cruelty, like harassment, like demand for dowry. It is not restricted only to, you cannot say it is restricted to only urban or to the rural area. Similarly, or for the educated or uneducated class. Similarly, cybercrime, we can say that it is also not only restricted to educated or uneducated class, because those who are educated enough, they also sometimes falls in the trap of the predators. And the law which has been available, this is we cannot say that is effective enough to curb the crime against women. Now, at the time of COVID, what the cyber experts basically said, that there is increase in the crime of sextortion. Term which has been evolved from, we can say, from the term extortion, which we all used to read under IPC. Here, in this, at this time, or this type of technology, we have another term, that is sextortion, which includes extorting money or sexual favors by threatening someone. And how it has been done? It has been done by the morphed images, which means by changing the faces of the people, especially females. So the NGOs who are working for providing cyber security, they have said this thing, that at the time of COVID, doxing is one of the crime, cyber crime, which has increased. Similarly, sextortion is again one of the crime which has increased by the help of the morphed images of the female. And for this again, concrete law is not available. We have to see to the special laws, and we have to see for the other laws also. And whatever kind of punishment is mentioned under the cyber laws is not stringent enough to curb cybercrime against women. And therefore, we can say that at the time of COVID also, crime against women with the help of technology has also been increased, or it is something not restricted only to the females who are coming from the urban or from the rural area. Next comes the aspect of privacy violation in the online space. So as we all know that there were several sites are being created by using certain fake IDs. Similar instances happened at the time of COVID also, where some fake sites have been created for tracking the cases of coronavirus. And what these sites basically did, they used to take the photographs, they used to take the location, they used to take other information, personal information, and from these apps also crime against women has been committed, because they were being present in the play stores, and people were sometimes downloading it also, or they were accessing it also with the help of the links. And what happened, that it is a malicious app which has been made for violating the privacy. And again, privacy is something which is closely connected with the basic right of the individual or the human right of the person. And in all the treaties, if we talk about the Bill of Rights, especially in on all the three documents, privacy has been given a place. Right to privacy of a person has been given an important place. And similar is the case in India also, where the Constitution says under Article 21 that along with right to life, there is right to privacy also. And we have the famous judgment of K.S. Kutuswamy. So privacy violation, which is again a part of, which is again a basic human right, which is again a basic fundamental right in Indian scenario, it has been violated, and the females have been again trapped in such kind of crime where their personal information has been leaked. Similar things happened, like I have not mentioned here, but if you read newspaper, you can find it out that online shopping, because at the time of pandemic, we were more inclined towards the technology, we are more inclined towards those online shopping apps. And in that, certain new kind of apps or new business was also being made. And from those online shopping apps also, women are being targeted, and then they were have their money is something which has been extorted, or their money has been taken. So on one hand, the cyberspace is something which has been created for helping the people, for protecting the people, for making the transactions easy. At the same time, it has been used for violating the rights of the female. And this is what something that National Commission for Women said, that why the females were facing digital crimes in India, it is because of the lack of awareness. And the National Commission for Women also suggested some views like we should not quickly just click to some of the links that were coming if you're not do not know the person clearly, we do not accept the request very frequently, if we do not know the person. Fake IDs are being created. More than half of the IDs that are being present on the social media platform, they are being fake. So, and then how the women are being trapped from the predators, because they were not aware. They were using the technology without any kind of digital literacy. Now here the data which has been provided by the NCW in the year 2020, where you can see the cases, especially the cybercrime, which has been raised, like 704, but prior to that, the cases related to cybercrime were very less than 50, like very less cases were there. But at the time of COVID, it has been increased rapidly, and later on, rest of the traditional crime has also been increased. Now, coming to the role of judiciary, what happened that in India especially, that the Delhi High Court has asked the National Commission for Women, NCW, and the Delhi Commission for Women, that is DCW, that is to submit certain written notes or measures what they were doing for the sufferers of domestic violence at the time of lockdown. Similarly, certain NGOs have also filed their petitions in the court, and court has also been said that the protection of women or the dignity of women is of great importance, and therefore even at the time of lockdown, states should make certain programs and policies or schemes for protecting such women. So ultimately we can say that at the time of COVID or the time of pandemic, the cases of violence against women is something which is not being restricted, and it is on peak. And what happened after that, or whatever we have read so far, that we have treaties, we are talking about gender equality, we have treaties, we are talking about equal status, we are treaties, we are talking about the equal space, life, liberty. So what we can say that in this global scenario, whether this gender equality a myth, or whether this gender equality, when we are talking about a safe environment, human rights for all, human rights are for everyone, so whether this aspect of gender equality a myth. So with this we can say that crime, which is again or violence, which is again a violation of rights of a female. Now here at the time of COVID, what happened, we are shifting from the traditional to the non-traditional kind of crimes, but ultimately we do not have certain stringent laws for curbing the crime against women. So what is the requirement right now, or what is the requirement that if certain situations, such kind of situations occur, then we should have the stringent policies, we should have the stringent laws. Along with that, digital literacy, and the female must be aware about her rights, for which again there is a need of help from the governmental as well as from the non-governmental organization. That is something which has been provided, and then only the crime against women can be stopped or it can be restricted. So this is all from my side. Thank you so much.
Hello. Now it's over.
Yes, ma'am.
Okay. Before Sonali comes for the formal vote of thanks, if anybody has any question to ask, really, Shashya, it was a very mesmerizing lecture. Very nice, very exhaustive.
Thank you so much,
Covered
ma'am.
various, you
It was
covered
so
various aspects of
comprehensive.
the topic.
It was
Yes,
so
yes, ma'am.
comprehensive that
Yes.
I think there is no question from anyone. There cannot be any question from anyone.
Yeah. You have covered each and every point.
Yeah,
National law, international
very
laws.
comprehensive. Very
Yeah.
comprehensive.
Okay,
Shashya,
Sonali.
congratulations.
Okay,
Thank
ma'am, you
you.
have to say anything?
Ye-
Our other faculty, Ajay Singh Kushwaha ji is also here. And Ashwet ji is also here, I think.
I have joined with Shikhar Saidi, I think.
Oh,
yes,
Okay.
ma'am.
good afternoon, ma'am. Good afternoon.
Good afternoon.
Thank you so much, ma'am.
Okay, Sonali, now over to you for the formal vote of thanks.
Okay, ma'am. Thank you. Since every beautiful time has to end, so it is with with this session also. So now the time has come to wind up the session. This brainstorming session given by Ms. Shashya Mishra has come to an end, and I'm here with the opportunity to present the vote of thanks for this session. Firstly, I would like to thank our very own Ms. Shashya Mishra for her wonderful lecture. I would like to point out that Shashya, you have taken this alumni lecture series one step ahead with your enriching and thought-provoking ideas, which has been presented in this lecture. And you have taken our attention towards the plight of women, which they have faced during this COVID period, which is very important for us because obviously women represent the 50% of our population, but their plight remains to be unsaid and unheard sometimes. So thank you for this thing, Shashya. Further, I would like to thank and express my gratitude to all those people who have made this lecture series possible. For this special thanks goes to our department, the faculty members, Preeti Mishra ma'am, Preeti Saxena ma'am, Rashida ma'am, Shashi sir, and Rashwit sir and Ajay Singh Kushwaha sir for their efforts for making this thing possible for us and to making efforts to make this kind of lecture series so that all alumni should connected with each other. There should be something happening in this platform, in this arena. Further, my heartiest thanks goes to the president and the office bearers of this alumni association. They have really worked very hard, and they have really put their efforts up to the mark so that we all alumni and faculties, we can stay together, stay connected with each other. Thanks to everybody, and a special thanks again goes to the people who are associated with the department who have made this thing digitally possible, Kamruddin Bhaiya and Sadhguru Bhaiya, for their efforts. Thanks to all of you. Again and again, thanks to all the participants who have joined this lecture series and made it a huge success. Thanks to all of you.
Thank you
Thank
so
you,
much,
Sonali.
Sonali. Thank you,
On my
ma'am.
behalf, on behalf of the department, on behalf of the Alumni Association, I thank Sonali for gracing this occasion with her sweet and smiling presence as ever. Sonali, your turn is also due. Sometime,
Yes,
whenever you have time to give
yes,
a alumni lecture, you are
sure.
also invited to present your thought on this forum. So, from all those who are present here, from the core of my heart, I thank you all. Thank you so much for being here. A special thanks to Shashya, Sonali, and all the faculty members and all the dear participants. Thank you all. Thank you so much.
Thank you.
Thank
Thank
you,
you, ma'am.
Sonali. Thank you, ma'am. Thank you, everyone who's been present here. Thank you so much. Thank
Thank
you.
you.